What is up, everybody? Come on in. It is so hot that we need to have a cool off. So again, good afternoon. We're also going to have what we call a educational drinking session because it is imperative that during the time that we would have listened to, we heard the awesome closing argument by Alan Jackson. Then we had to sit there and just count the seconds and the minutes for Lally to be done. And then we got to Bev, where Bev was like, hey, now I get the mic for an hour. And people were totally checked out, right? So this is going to be on 1.5 speed, which is perfect. When you guys hear this bell, it is your time to take a sip. If you guys have ever played Power Hour, I'm taking you back to your youth. At a couple key points, I will press pause and point that out. But I think that we're going to all be very surprised when we actually listen to this now, because we're listening for something specific. We're listening to see what's up. So, again, come on in. This is Bev's on Bev, guys. Bev's on Bev. Okay. What the hell did that jury do? Or was it Bev's fault? Or what was it? All right. And I'm sorry right now. I'm telling you guys, Bev says I'm going to give the jurors 3 or 4 copies of what I'm about to read. So let that think in. Only 3 or 4 copies were in that room for them to then say, okay, hey, we got to the room. Let's read what she said. You know, it's hard to listen to something. I want to be seeing it while someone's reading it. I'm a visual learner. So that means that if there's only 3 or 4 copies that went back to the jurors' room, that means I'm reading it. There are going to be some people that were I didn't even read it. Okay. Why weren't there 12 copies? Why wouldn't every juror get their own copies? They couldn't make copies for everybody, that they had to have just 3 or 4. Think about that. Now that just, when I heard that right here off the rip, because I reviewed this, I said to myself, well, shit, no wonder why nobody read the damn jury instructions, because there's only 3 or 4. And we know how everybody is about putting a bed together or a chair together. You don't read the instructions. You just go at it. You just look and you're just okay, yeah, that piece goes with this and da-da-da-da and da-da-da. Let's be honest. People would get stuff wrong on tests all the time because you didn't read the instructions. And is this jury responsible for totally failing Karen fucking Reed? Okay. Or is this, Bev's fault? And I think that we're going to be surprised. I do. And see, I'm not biased, so I'll call it as I see it. I'm not so I think Bev's a bias B? Absolutely. But not everything that she does and has done has been biased. So let's see what it is. I wanted to stall here for 5 minutes so people can get in it and start right from the beginning. So again, you're going to hear this. You take a sip. This is going to be a good one. Here we go again. The speed that we're going to be at is, I have the subtitles. I want those on speed back. It's 1.5. Okay. Because Bev doesn't talk that fast. And all of the facial expressions on the thumbnail came from right here, this little episode, you can call it, as well as when Bev walked in the courtroom and said, I am not recusing myself. Just because you see a little thing online about me knowing somebody, rumors, blah, blah, I'm not recusing myself because of rumors. So that was a picture to the left. Yes, I will be doing Idaho 4 today. Absolutely. Idaho 4 is my big Sunday Night Live with Brian Drake, because I'm revealing sex counselors and porn addiction counselors. And I have a link that links Brian Drake's family to Kaylee Gonzalez's family with a very good friend that was both of their friends. So I'm going to be revealing that. It's going to blow people's minds. So here we go. How did the jury screw up so badly? Let's find out. Me and Jack Brown. Here we come. Woo! Yes. Okay, here we go. Yes, this is the first domino, guys. Everybody down here? Shout out to all the people. Oh my God, I fucking love you guys. I better see you guys email me.
All right, jurors.
I want to go with cocktails.
Thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purposes of reaching a verdict in this case. But before you do that, it's my responsibility to give you instructions concerning the law. The instructions are divided into 3 parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you...
Okay, right there. She says, if there's anything that I say different, go with what I said versus what's written down. I have a question. If she's reading from a piece of paper, how could she possibly get it wrong? Did she actually mean to say, go with what's written, don't go with what I said? Because if she's just reading from a piece of paper, why is she telling them, go with what I said, not what is written? Cheers.
What you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part 1 of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the...
Miss Reed is presumed innocent. So the jurors are listening. Miss Reed is presumed innocent.
Charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. I will explain reasonable doubt in just a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find...
Right there, she said, on that charge. On that charge. She's reading from a piece of paper.
Find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt.
She's using the word charge.
Is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every...
So your moral compass has to just be about what you are seeing. Another sippy poo.
Person is presumed...
Your moral compass cannot be anything outside of the evidence.
To be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead,
that is not enough. probability is not enough, you guys. That's like probable cause. Probability, the Commonwealth bringing up some probabilities, not enough.
The evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt.
See, so this actual moral compass and when they want to use the word moral, it should not be with the people that are talking. Like, the guilters should not be saying that I can't find her not guilty morally. Okay.
Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so.
The jury decides what's fact and what's not. Okay? Just because it was presented to you does not mean that it's fact. Okay? The jury decides out of what they have, what is fact.
Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and...
Those letters prove that whoever wrote those letters, that's passion, right?
And impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged, or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence, so that here in this
cool, reflective, oh my God,
courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you...
In case you're just joining us, every minute I will stop and I will shake the bell. When you hear the bell, so if you're not watching, you're just listening. When you hear the bell, so if you're like laying out and you're tanning, you take a sip of your drink when you hear the bell, and the bell comes every minute.
Must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show The importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should.
Right there, reports under their rules. Certain reports are not allowed to go in. Remember the first question they asked, where's the cert report?
Should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may...
Bev is saying that there's redactions in stuff that they're going to have back there. Don't pay attention to that. Don't take it negatively.
Have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions, and the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law.
She said with a certain clinical detachment. They wrote in their letter, state of mind. That speaks clinical to me.
To that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use.
Notebooks are not evidence.
Please do not share them with other jurors.
Please do not share your notebook with other jurors. So this was written on pieces of paper back there. So if they're trying to have like debates back there and go over things, and anybody was to say, no, you could say, hey, for my notes this, or for my notes that. That's interesting to me. Like, why do we take notes then if we can't, you can refer to them, but that doesn't mean that they're gospel because you could have got it wrong, but
consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open.
So what she's saying there is don't go in there and say, I already have my mind made up and I'm voting this way. Okay. She's saying that don't say anything like that. Go into the room and start discussing the evidence. Okay. That does not, nowhere near does it say when her rule, her instructions there, does it say you can't have a partial, what I mean? This is just about like when you get in there, it's a way of basically saying don't get in there and say all for guilty, all for innocent, something like that. It's go through the evidence first, everything that you're going to have back in that room.
An open mind until then.
And keep an open mind until after you get to go through all of everything.
You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations, and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented.
Sippy sip while you sippy sip. So I have my notebook and I say, hey, okay, I'm going to write down every witness that came through. And we have our little Sharpie pens here, AKA memo, whatever you want to call them, these little things, and expos. And so I want you to, we all have initials, like whatever, mine's LO. So next to each witness, I'll come up here. And if you believe what they had to say, put an initial down. If you didn't believe what they had to say, don't initial it.
Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the
Okay, this is written down. This is really important. So there's going to be 3 factors, and she says, hey, things, she's bringing it to the attention, like you're allowed to consider this, which would mean that anybody that's going to talk about any of that evidence, okay, when they're going to go in the deliberating room, if you're going to bring up evidence that wasn't collected properly, all of this stuff, we're going to have a huge problem. Okay, so listen to what she says here. She's reading it straight from the paper.
Omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted test or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limiting instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reed had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe.
And so basically the jury was like, yeah, fuck all that. They shat all over that, allegedly, because they threw out murder.
Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were, in fact, John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and or the defendant. If you do not find it is more likely true than not that John O'Keefe, Karen Reed, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can infer from the evidence that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. And
this would go to everything that everybody is saying. It's hearsay, you know. I hit him. That's what this is in regards to.
Determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances.
Totality, keyword.
Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witness testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of these witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the assumed facts are true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. Now, you have the same powers with respect to the exhibits that you have and the testimony of the witnesses. Look them over and decide the weight. That is the value they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it is written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what the exhibit purports to show.
Okay, so take a sip there. Basically, anybody that's going to be arguing that room and saying, like, look at what these professionals, these experts said about the whole vehicle, couldn't have made those, would have had bruises, could have made, the argument inside that jury room, this person or people would have grabbed this piece of paper and said, here you go. Just because they're so-and-so, just everybody in this case or any case, just because they're so-and-so and they have any type of title, this piece of paper is telling me that that doesn't hold any weight. It's what I want to put on it. And the piece of paper is telling me that. So I am telling you the arguments that were probably being made in that room are right there off of what she just read. That would be shown to people. So everybody that wants to say the crash daddies, did it for me. They did it for a lot of people, right? In that room, though, what a person would be doing if they want to try to get Karen Reed on manslaughter, here you go, because they're going to say, then you believe in the conspiracy. Because if you believe that car didn't do it, then you believe in this whole big conspiracy. And you're using that part of the jury instructions to persuade and influence. But you're going to come across and not act like you're doing. You're going to say, well, here's what she says with this. So it's just because this person has that title. It's what we, want to put on it.
And how much weight, if any, you give each exhibit. Now, you've heard me talk about the sources of evidence in this case. Those are the tools that we have to decide the case. Now, with the evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense.
Right there. As a juror, you bring all of your knowledge and common sense with you. You do not check your common sense at the door. You bring everything in your life and your history and everything that you've done right there, guys. Shake that bell, because that, again, is going to be something that, here's my jury instructions, okay? And I'm going to point that out. All right. Hey, guys, this is what I've done for a living. I'm a cop. I'm this. I'm that. I'm a doctor. Wow.
At the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have
None of those jurors did this. If those jurors would have done this, woo! NGs across the board.
To decide which inferences are reasonable and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate.
You may not guess. You may not speculate. Okay? I'm going to slow down Bev here. I have her as slow as possible. I want to just I just want to back up one minute back. Okay. Check this part out again.
Of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable.
Logical deduction. Okay. And this is where I would have stood up in that back there in that room. Logical deduction, motherfuckers. Boom. Can I get a shirt that says logical deduction? That's everything. So timelines are logical deductions. A timeline of Karen Reed hitting the Wi-Fi at John's at 12:36 a.m. and the vehicles that would have been there at the same time and would have witnessed this happening is logically provable that we would have witnesses all of the action. The offense would have been witnessed. That is logical deduction based off of a timeline. And wow.
Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise.
You may not guess. You may not speculate.
You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore.
I mean, these jury instructions, you guys, I'm sorry. I think they are amazing so far. I truly do. Especially if like she's reading from a piece of paper that all of us then would go back in that room and read and have for our arguments with other people in that room. Okay. I mean, there's nothing confusing. I'm sorry. This is everything literally that she is saying is leading you down a path of not guilty based on reasonable doubt. Reasonable doubt is everything. In these jury instructions to this point, this is all about reasonable doubt. She doesn't have to say the words reasonable doubt for all of this, guys. If you are a logical, common sense mofo, come on. And
when you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the...
Did you just hear what she just said there? One more time. One more again. 30. Here we go.
It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt.
And the world shall just be, woo! What did these jurors do in that mofo room? Oh my God, she is reading from a piece of paper that they all had. What are you people doing? And then wait, it gets way better.
Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today.
Okay, here's her hypothetical. Here's her hypothetical. Ready? Suppose you have to determine if the U.S. Postal Service delivered mail today. Ready? Here's what she's giving these mofos.
If you go home and someone in your household, a child, roommate, or spouse, hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible.
Wait, what about the fact that the mail has a stamp date on it? Are we going to talk about that?
On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I have just described.
Oh, Bev, what a horrible, horrible analogy. Because there's going to be dates, okay? But I guess it's the date that it was stamped, and I guess it could come a day later after that. At the end of the day.
You may have noticed that the defendant did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that the defendant did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. All right, that completes my first part of the instructions.
Okay, completes the first part of the instructions. There's a double whammy. I want to answer this, you guys. What she is saying is that you guys are the jury. You guys get to hear everything, and then you determine what the facts of the case are. Because testimony, there could be lies that when people testify, right? And so therefore that's not a fact. So this is the normal thing when a judge says that you guys determine the facts. Out of everything that you're going to hear, you determine on, hey, this person was credible, or hey, this is this report says this, but I don't believe for a second this report. Okay? I don't believe for a second, the report says certain things. I don't believe for a second that shoe was found there and that it had always been there and that the Canton Police Department just missed it, So she's not contradicting herself at all here. She's saying that you guys are determined, like you guys get to pick and choose as a collective unit in totality what you guys are deeming as credible or not credible to make it that these would be the facts of the case. What both sides are presenting is their case. Just because one of the parties presents something does not mean it's fact. Okay? Just because one of the parties is going to allow, like Lally, asking questions to allow people to lie on the stand is not fact. So that's what she means to answer that question. Moving on. Now we're going to the part 2 part.
Now I'm going to turn to the elements of the charges against Ms. Reed.
Now, elements of the charges. This is important.
The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree,
they use the words that Karen Reed beat him. Did you guys just see that?
the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural.
So this has to happen. So they have to check this in their like minds or whatever, saying, okay, do we think that this happened? And it's like it has to be and this, not or this. So this is the first part. So do we think this part?
Natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death.
So 1, that's an option.
The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe.
Or this.
Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating...
Okay, so that was the first. That's count one. And so once they would have all talked about this and they saw that the elements were not met in none of the prongs of that second, so hey guys, it's not guilty. So on our juror slips, if we all have to be filling these out, each one of us should have had our juror slips and it would have been checking off not guilty on that juror slip. So what one of my huge problems is that because I'm crazy about, you guys could say like, oh yeah, Lana prints everything out. She puts it on Hector, blah, blah. Yep. I'm going to make sure that my paper is not going to have any creases in it whatsoever. And, but my paper is going to have the check mark for not guilty. Okay. And I'm also going to be the weird one that is going to initial it and put a timestamp as to when we went ahead and did that. There would have been a timestamp next to my check mark with the LO circled and then what time that was at and the date. Okay. And then, so if we all have our own slips, whether or not you want to do your slip like that, but definitely on your slip should have been the check mark of the not guilty on count one, right? Now, here we go. She's going to go talk about the next one. She's reading from a piece of paper that we all get.
Operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she...
Okay, so we have our slip here. And everybody could say, yep, she operated a motor vehicle. Check that. Check it off because we have to go down them.
Operated the motor vehicle upon a public way or in a place in which the public has a right of access.
Yep, she was on a public road.
Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. You'll have both these choices on the verdict slip. Fourth, that the defendant operated the vehicle.
I would check yes to that.
Wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that
I would check no to that.
By such operation of the motor vehicle, the defendant caused the death of John O'Keefe.
And I would check no to that.
So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle.
Yes, they did.
A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion.
Yes, she did.
Person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion.
Yes, she did. She was driving.
To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is
the cameras prove that she was on a public street.
Open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence.
That's why I would be saying yes to that, just so you guys know. But just because I say yes to that, because you have to say yes to all of the elements in order to find her guilty of that. Okay?
Of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading.
So the reason I'm checking yes to that, again, you have to meet all the elements. So that's only the third part of it. Because then the fourth and the fifth part of this, it's no and no. So then if you don't make all the elements of it, okay, it's out the window. Okay. So this is not about that they had to prove that she was at a 0.08 or higher. This is about, do I reasonably believe that she was under the influence? It has nothing to do about anything to do with the amount. Okay. Do I believe that she was under the consumption and the influence of alcohol? I do. But do I believe that that impaired her at all? If you're going to ask me all of that, no, I don't. But the next thing, so it doesn't even matter if people in that room want to say yes to that. Let them say yes to it. Awesome. Sounds great. Because this is the next part.
Is the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a 0.08 or greater.
That is no. I do not believe that that was proven.
The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly.
And all of that gets a no for me. Okay. The reason I'm going off of that she was drinking is I'm going off of the receipts. I'm going off of my eyes watching. I don't believe that she was taking, I don't think that she was just consuming waters. Okay. And I believe off of the receipts that alcohol was consumed. Again, there's 5 elements here. This one right here, though, you're going to get a big fat no from me because absolutely not. Nobody even knows who took the woman's blood test. Nobody even knows who took her blood test. Nobody testified that they were the person that took the blood. They testified that they got her blood, which how do we even know it was her blood? You know? So, so again, you get a yes that she was on a public driveway or street or whatever. You get a yes to me that she was operating a vehicle to begin with. Then she's on a public roadway. Then you're going to get a yes to me that I do believe that she was consuming alcohol. But then right here, this one for no. Did they prove that it was that she was intoxicated? No, absolutely not. And in fact, everybody testified that nobody came across as intoxicated.
You may also consider any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point. Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are in.
Okay, and what we have from here, the evidence shows that we have her arriving. I'm sorry, we have camera footage of her not driving erratic at all. Okay, she is not she's not speeding. She's not blowing any stop signs. The evidence that we have, 100%, she's not driving recklessly or with the intent, anything like that. She is not. In fact, everybody beat them to the house. Okay, and they got there a couple minutes later. So, and there's no evidence of her speeding, of her breaking any of the, we don't see her swerving all over the place. Nothing.
Different to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is,
again, this whole stream is about, this is the jury instructions. And when you go back to that room and you have this form in front of you, okay, you have the form in front of you, but you also have these juror instructions in front of you. Okay. And so, this is about going through how in the world did the jury screw the pooch for Karen Read? Because they did. Okay. The jury is screwing the pooch, and they did for Karen Read. And they're the only people that can make it right. And it's going to take a lot to make this right.
Is acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead.
No.
Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element.
Yes. I believe that she consumed alcohol, which is not a crime. And so therefore, that's why it's the third box that I checked. Now you get to this fourth box, which she's just explaining here. And that's why I'm saying no, no, and no. And once you have a no, then you did not meet all of the elements of the crime. Just because one of those boxes is a yes, and I say one of those boxes, and they call it elements, you have to meet. It's like if you guys ever took probability stats class, what is the probability that you have a dice and you're going to roll it and that it lands on a 6? And that the next time you roll it, that it lands on a 1, 3, or 5, like an even number. What is the probability? That means you have to take the first probability, which would be 1 out of 6 chance that you roll it and it lands on a 6 or a 1 or whatever number we're saying. And means then you have to add it. And this would then have to happen, which is that we have to then roll an odd number. And then what's the probability of that happening? Both things have to happen in order for, that's what this is all about. You have to go through the elements, and it's not or. The key word here is and. So it's this. Okay, check it. Then that means you can continue on. It's like filling out your taxes. When you go to certain boxes and then they say, okay, did you fill out here? Okay, then that means you have to go on to box, 3. And all of those things have to be continuing you to continue on going. Once you get to a no, then that charge is off. It's gone. And here we go. Ring, ring, ring. Take a sippy.
Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need.
You guys, is not causing any confusion. In order to meet the elements of the crime, okay, who wrote that? It's not. Your piece of paper says that this would have to happen, then this has to happen, then you believe that happened. And when I say that you believe it, it's because it was proven. That's how every piece of the crime is that you're ever going to be on a jury about. If you think that that's confusing, I'm sorry, but then there's no place for you to be a juror. You guys, in order for you to find somebody guilty of something, whatever the elements of that crime consist of, the Commonwealth, the prosecution has to prove all of the elements. All of the elements of murder. She just read off what all of that entailed. Okay. Then there's now, so she's reading off what all these charges are from her paper that everybody had. And she's telling you that they have to have proven beyond a reasonable doubt every single element of it. Otherwise, it cannot, that means they didn't prove it. It's a not guilty on that charge. Then you move on to the next charge. It's true. This is truly not difficult. Now, maybe the juror slips, but what she is saying is not confusing. I'm sorry, but none of this is confusing.
Need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation,
What I just
the
said.
defendant's physical condition, and how
Perfectly
well the
fine.
defendant could see
Perfectly fine.
and could control the vehicle,
Perfectly fine.
the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe.
Right there. Okay. So she just said 5 things like, and this, and this, and this, and this, and this. If they proved all of these things, then that's the only way that you can get to a guilty verdict on that charge, on that count. Okay. And the answer is, even if you checked yes for number 3 and 4, this one right here. So let's say that they went, yep, she was on a public street. Yep, she turned the key. She was driving. So that was actually first. Then there was public road. Now, did she consume alcohol? Yep. Do you think that it was proven that it was over? Yep. But right here, did she cause it? And the answer, if this becomes a no, then does it not matter with all of those things that you said yes to? Doesn't mean shit. This then gets thrown out. It's a no. Because you have to have all of the elements, not just one or half or all of them. Woo! Woo! And did the Commonwealth prove that? The answer is no. Because you have to meet all of them. So that's what I'm trying to say. I'm trying to give people the benefit of the doubt with when you're in the jury room. And let's even say that they want to check off that, yep, she had alcohol. We saw the receipts. Awesome. Yep. Then the guy came in and testified, and woo, look at this result. It was just so off the wall, right? Let's even say if those idiots want to say, yep, sure to that. But those next 2, these are no's and no's hard because they didn't prove it. Not even they did not prove that. The other stuff, if you want to even say that they proved, but this part, no. This is easy.
The defendant
when I say easy, this is not confusing yet.
Caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all 5 elements beyond a reasonable doubt, you shall reach.
And now if anybody wants to say that she dropped him off there to get his ass beat, the Commonwealth did not even have that as something that they were even saying could have possibly been the case. So you just can't make that shit up. Okay? You can't just go into the deliberating room and say, well, guess what? She dropped him off there because, she knew what was going to happen and they were all going to get in a beef. And so she knew that was going to happen. That's not that. That's exactly what she's telling you that you can't do in the deliberating room.
Return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes.
Okay, so here we go. Now the lesser offense. Okay, so this is what she's going to say when they want to say the lessers, the lessers included. Like, here's now one of the lessers that was under count 2. Okay, here we go. And by the way, welcome to the transparency. Here we go.
It's the lesser offense of involuntary manslaughter.
Involuntary manslaughter. Okay, a lesser.
Matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter.
So here we go. So we did count 1. Count 1 was just the second-degree murder. All those elements don't even come close. The jurors supposedly say that it was completely off the table. We just went through then count 2, which should have been completely off the table. But now we're getting to, this is the lesser, which was under count 2. All right, so here we go. These are read verbatimly, allegedly, off that piece of paper.
To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First,
beyond a reasonable
that the
doubt,
defendant caused John O'Keefe's death.
That's number 1. That's what number 1 is. Number 1 of the elements is that they proved that she caused his death. Is number 1. That's element number 1 of the crime. Did the Commonwealth prove that Karen Reed is the cause, that Karen Reed caused the death of John O'Keefe? What the how is that difficult?
Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless.
You understand that you can't just say like, oh, yeah, we think one of these and then that's a guilty. No, these are the elements. That means you have to meet all of the elements.
I will now discuss each element in more detail.
Here we go.
The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act.
So in a deliberating room, this is what I believe that would have happened. Even the people that think, like me, who I would think is normal, John O'Keefe was not hit by that vehicle. Okay? But she took him there and she dropped him off. Okay. So her actions by dropping him off or leaving him there caused his death. Are you insane? It is not reasonable to think that Karen Reed or any of us would think that we drop somebody off at a house where they have friends would then die because I dropped them off there. So when I was trying to give like benefit of the doubt to Stu Nods, I can't even get there. This is unbelievable. Okay? Absolutely unbelievable. Oh, bell time.
In a natural and continuous sequence results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption.
As soon as they said that John O'Keefe didn't go into that house, the Commonwealth, their own statements saying that he didn't ever went into that house, the Commonwealth isn't even attempting to prove this shit. Okay? Make sense? In fact, they had all these witnesses to say that he never went into that house. So how can you possibly get caught up on any of this shit? Honestly, but this isn't confusing, though. This isn't confusing. It is natural that it's you have to prove all of the elements of the crime, because it's like anything. It's like, what do you guys mean when to prove when somebody says like, hey, we're going to give them manslaughter instead of second degree or first degree murder? Why do you think that they say they're going to go with manslaughter? Because of the element to prove murder is you're not going to be able to prove intent. So that's why we charge them with this, because the elements of it to prove, like you cannot prove this. You cannot prove that. So it's really, truly, it's not confusing, because every crime has elements to it. And this is all written out, and I'm sorry, but it's not confusing. You have to prove all of the elements beyond a reasonable doubt to vote guilty on that.
Consumption of alcohol.
Otherwise, it's not guilty.
The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if
you know what that means right there? That her leaving him there subjected him to grave danger. You understand that? Yeah. Okay.
Defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. The
only way that you can find on any of this is if you believe. You have to start with the whole thing that you believe that not that you believe. Fuck the word believe. You have to say that the Commonwealth proved to get to any of these that the car is what caused the problem. Okay. That the Commonwealth proved that the car was murder weapon. I don't believe that the Commonwealth proved that. And that alone that element has to be met on everything they're talking about.
Deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide.
Okay, so this is the second lesser on number 2.
felony OUI liquor, and negligence.
Okay, so here we go.
As a
Let's see.
matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now.
Here we go.
In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reason.
The following 5 elements must be proven. Each element beyond a reasonable doubt.
First, that the defendant operated a motor vehicle.
Yes.
Second, that she operated the motor vehicle upon a public way or in
Yes.
a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and
Intoxicating, not consumption. That's different. That key word. Consumption versus intoxicated level. Very different words there. You would circle it, you would highlight it.
and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people.
And they did not prove that. They did not prove that. In fact, if you really want to go as far as to say a ton of shit, they didn't prove that damn Karen was driving the vehicle at the house of 34 Fairview. You want me to go far as to say that? They didn't prove that Karen Reed was the one that was driving that vehicle at that time. Who's to say that Higgins didn't get in that vehicle when they were there? You want me to get fancy with your pantsies? Because I can. But that part is to say, like, it's to going that you're driving in a negligent way that would have caused it. And let's say that, how about this? They could not say that even if you want to say that she hit him with the vehicle, nobody testified to what the cause of the death, like, did that cause his death? And you guys, people would have saw that. People would have saw that. I have no damn clue. When I say, what were these jurors doing? What is going on? What is going on in that room? And now you want to listen to what these letters they were writing? Ah!
A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires.
This would be the only thing, in my opinion, where if you're going to have a split room, it's going to be on this, because everything's going to be like, even if they said, okay, element, met, when you get to this last fifth one, you're going to have a split room, because on this, which was where you're going to be your hung jury is on this, is because half of them think that the car caused the death, but the other half doesn't think that the car caused the death. So right there, that's where your hung is going to be, and everything else is not guilty. Like charge 1, then charge 2, and the charge 2, then the first lesser, you're getting to this second lesser, and this is where it would be hung. And then when you go to the count 3, that has everything to do with count 1, because it has to do with knowledge. You have to knowingly know that you did something in order to flee the scene, blah, blah, blah.
Requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address.
See, so this is why they threw out 1 and 3 so quickly we're off the table, is because 3 has to do with listen and read the words knowingly. No, she didn't knowingly, like they're saying, like, no, there was no intent here. She didn't knowingly do anything. And so therefore she couldn't leave a scene that she knew was a scene, because she didn't know that she would have hit him. That's why 3 it goes with 1. If you're throwing out 1, you're throwing out 3.
And registration number of the motor vehicle. And 6, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. Save a little time for you. Right? As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Now that completes the second part of my instructions. I will now turn to the final instructions. In order for a jury to return a verdict, that is to reach a decision in a criminal case.
Okay, so this is what this should be the part that everybody wants to talk about and say, okay, what like, in order to return your verdict, let's see how this goes. All right, so stretch your arms out. All right. Now, this is the part that has everything to do with the motions. I believe that none of this parts 1 and 2 were confusing at all. And if you think that they were, then you should have nothing to do. You wouldn't have gotten that far to even be on this jury. Okay? So here we go.
The law provides that there may only be 12 persons on the deliberating jury, and you will note that there are still 14 of you. To avoid the need for a new trial, if one or more jurors becomes ill or has to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. However, when you begin your deliberations, the law of Massachusetts is that there can only be 12 jurors. Therefore, at the conclusions of my instruction, the clerk will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate.
So this is what she's saying, that at the conclusion of my instructions here, there's, as you guys see, there's way more than 12 here. We are going to be cutting it down to 12, and this will happen at the conclusion of my instructions. So let's see if she keeps that, okay? Look at Jen working on that base tan.
Alternate
Oh, wait.
jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted because, as I've indicated, it is important that we have extra jurors in the case of emergency. If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused, we would have to try the case all over again with the new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start their deliberations all over again from the very beginning. Therefore, it is important that the alternates not discuss the case with anyone, including each other, for if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not influenced by anyone else. Now, different states.
So that means that those alternates had to sit in a room and could not even talk to each other. They had to sit there literally and just wow, that's interesting, right?
And jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own
Here we go. Here's the foreman. Listen to the rules that she's about to give.
Foreperson. In Massachusetts, the judge is responsible for selecting a foreperson.
In Massachusetts, the judge is responsible for selecting a foreperson. Okay, so everybody out there that wants to talk about, what's Kim Bev just picked that? I'm sure that Yannetti would have stood up and said, I've never heard that in my life, right? He didn't. Okay, guys? That's the way it is. In Massachusetts, they pick the foreperson.
A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations.
So you're foreperson, organizing the deliberations.
Communicating with the court if necessary.
Communicating with the court if necessary.
During deliberations and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations, however, in that sense is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400. Would you be our foreperson, please, sir? Thank you.
Okay. Now that's where it may be interesting to me right there is that, so according to Mass, she picks the foreperson before they eliminate who could possibly be. So that, and I'm guessing that that's how they do it. All right. And so she would have had her mind made up already. So then his number wouldn't have been in there. Okay. Or that person, if it was a boy, girl, whatever. So, and I'm telling you, if there would have been an issue here, because they all looked at these rules and instructions before, okay? So this is normal, but who she picked the foreman. Now, what's interesting is if you listen back, it doesn't say that if the foreman is the person that communicates with the judge, should you need to. It doesn't say that the other jurors, like, I disagree with what the letter that you're going to write. So is it going to come out that we had no idea what this letter or these letters were being written and how they were being written, because he showed us the instructions and he was like, well, it's my say. It doesn't say that I have to confer with you guys when I want to communicate. So that's what's going to have to come out. If that comes out, I think then we can get somewhere. Okay. Because what doesn't make any sense is the letters that were being written by that foreman to Bev. It contradicts with what the jurors that have come forward have said. So they're going to have to go at that man and, say that his letters were absolutely ridiculous. You get what I'm saying? Like,
when you return to the jury room to deliberate, the court officers will deliver to you all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge.
As to any charge. Do you guys see that right there? Boom! This freaking jury can literally fucking piss up a fucking tree. I've been waiting for you guys to hear that part right there. Okay. You guys that want to blame the jury, you better start, because you're wrong if you don't. Listen to it loud and clear. Here it is.
Number 400, would you be our foreperson, please, sir? Thank you. When you return to the jury room to deliberate, the court officers will deliver to you all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge.
As to any charge. You guys, dude, they didn't read shit in that room.
That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not begin deliberating until all 12 jurors are together in the jury room, and should cease deliberating if any one juror is not present in the jury room.
I'd like to take a bathroom break. Hold on one second. I want you guys to hear that part again.
Number 400, would you be our foreperson, please, sir? Thank you. When you return to the jury room to deliberate, the court officers will deliver to you all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not...
On each charge. You should continue deliberating until you find a verdict on each charge. So if you are doing things the right way, like I have my slip here, right? We should continue deliberating until for each charge. Okay. What she means by that is we don't come to her and be like, okay, we found something on count one. Here's our thing on count one. We'll go back to the room. Now here's what we got on count two. Now here's count three. Here are the lessers. Okay. She just means that you're going to continue deliberating. Even if you've come to conclusions on charges, you continue to deliberate. Then once you can no longer deliberate, you're then going to reveal where the hell you stand, right? And that would have meant that you would have said we come to a conclusion on count one and count three and count two, if that would be the case, but we are hung on the lessers. She is reading from a piece of paper.
Not begin deliberating until all 12 jurors are together in the jury room, and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed a careful and thorough collective view of all the evidence.
I'm going to play that for you guys right there, that last part.
You not to take any votes until you have completed a careful and thorough collective view of all the evidence.
All she is saying there is that don't vote yet. When you get in there, don't be like, okay, who thinks she's guilty? Who thinks she's not? No, go and look at all the evidence, see for things that you may have questioned yourself. Hey, I've been waiting I want to see this, or I want to see that. Look over everything. Okay. But don't go in there and just start voting. That's all she was saying. Okay. It's not, she's reading from a piece of paper.
At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not consciously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should.
There you go. Suck on that. Suck on that. Don't be hesitant to speak up. None of them spoke up. This jury failed Karen Reed. Bev has not done anything yet. What has Bev is reading from a piece of paper that guess who wrote the piece of paper? The Commonwealth and the defense wrote what she is reading, approved it, and they're the ones that had everything just as much as she had to do with those jury instructions. Okay? And you know what I think? I don't think any of them read that shit when they went back in there.
Participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law.
Okay, I want us to listen to this part right here. I'm going to slow it down. Here you go. This is everything. This is everything.
Of a particular group. Fourth, I might ask myself, Would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer.
Oh my God. There you go. There you go. Whoa. We get to write her a note if we don't understand something. Hey, so we've come to the conclusion of charges, but we're at an impasse on others. Is that okay? How do you want us to do that? This is the jurors' fault. This is not Bev's fault at all. This is 100% on the jurors, 100%. These jurors are going to have to come forward and literally out the foreman if that's truly what happened in that courtroom, or not in the courtroom, but in that deliberating room. If there were, if there was jury tampering by means of influencing the other jurors, threatening, anything like that. What were they doing in that room? Exactly. None of them read this. None of them were paying attention. It is literally right here. She says it. She reads it. If they had questions, they should have wrote her. The jurors failed Karen Reed 100%. This is on the jurors, and anybody that wants to, oh my God, no, it's all Bev's fault. They were just so confused. Get out of town. No. No and no and no. Okay. They're going to have to come forward and say that we were crying because we didn't want the foreman to write the letter that he was about to write. We were all saying that doesn't even make any sense. We've come to a conclusion. So you're saying that we're in an impasse. We're not. We are at an impasse on one thing and one thing only. The rest we've decided. This is pathetic. Okay. These jurors didn't read, and nobody, if they did read, stood up to the foreman and said, no, you're wrong. Or look at, she says in black, ask her the question. Hey, we've come to the conclusion on X amount of counts, but we're at an impasse on one of them.
Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are.
What she means by that is I can't hear everything that you guys saw. You're going to determine what you think is fact versus what you think could be a lie or a report's not right. That's what she means by you guys are determining what the facts are. So I can't answer a fact question. That means about the trial, about the case, because I don't know the facts. Because just like you, I watched and witnessed all of this as well. And so I'm not going to tell you my opinion on what I think something is. Okay. But she can answer questions that have to do with the process. The process.
Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to.
Right there. If you So right here, they should be quoting Bev. The defense, their only argument can be that Bev said that she was going to confer with the counsel after she gets before she was to respond to them, she would consult with counsel. In that motion that they wrote for dismissal, they're not quoting this, and they should be quoting this part. Okay? This is what you would want to use, because the only thing that changed is her consistent approach on each question when it did come through. So you would want to quote that, and that's what you'd be saying, is that changed on the last go around. Okay? And then let them come back and say, well, we already issued the to Rodriguez, blah, blah, blah. But these jurors didn't have, you guys, the charges, each one is separate. Okay? And if you had a question on that, and if you felt some way, well, I don't feel, this doesn't feel right at all. This is like double jeopardy, blah, blah. None of you guys felt that in the courtroom when you saw the letters that your foreman wrote. You're going to have to come forward and say that you did not know that the foreman wrote letters like that, because he didn't share with us what he wrote. That's the type of shit that is going to have to come out in order for this all to possibly be fixed. But unless that's going to come out, this is going to stand as it should, because it's the jury that made the mistake. Okay. These jurors didn't read. These jurors didn't ask questions. And these jurors want to go through third parties. Okay. No, you're going to get your happy ass up to the courthouse, and you're going to make it right personally.
To answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating.
So there you go. Bev says that's why I was wondering why she sent a note in. And they were not the ones that were saying, hey, we want to leave, you guys. It was her that writes the notes every day, and to say, hey, are you still deliberating? Or like, did you guys want to go home? And that's why the note came that she read and made it seem like to all of us at the time, what do you mean they're writing and saying we want to go home? No, they were asked, like, are you guys are still deliberating, right? Yes, but we're not going to have a verdict or anything like that. So we would like to go home, when the time is up at 4.
Or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise.
Don't tell me, okay? Don't tell me or anyone else how the jury stands numerically or otherwise. We'll have it play.
You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict.
Once you've reached a unanimous verdict, you can tell her, though. Do you see that? Do you see that? What this means is that you can't write to her in your telling the court, hey, we are at 8-2 on count 1. But what you can write is, on count 1, we have reached a verdict because we're unanimous. Do you hear and see this? And these lawyers that have YouTube channels, maybe they all need to listen to this, okay? Anybody that's covering this case needs to play this for themselves. But once it would have been unanimous, you can say something. Please listen to this. Educate yourselves right here. Let's educate ourselves.
You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict.
Before such time that you've reached a unanimous verdict. And now, if you would have had a question, okay, it's a unanimous verdict on each count, okay? But if you would have had, let's say, the slightest of questions, hey, we can't tell her numerically this, okay? But it says that after we have unanimously decided a count, then we can. And so what it's going to come down to is this even puts more pressure on the jurors to sit here, and after they would have heard the letters that were read by the foreperson, because the foreperson wrote them, I believe that these jurors are going to come forward and saying, holy shit, we did not know that foreperson wrote those type of letters, because that doesn't even make any sense. Because it's making it seem like, as Lally wrote it, very simple, we haven't come to the conclusion of any charge. And so I don't know why you would ever write a letter that would ever believe that. Like, you wouldn't write a letter, you would not allow a letter to be wrote like that. So it is imperative that these people those letters contradict everything that they said that was going on in there. And it's going to take, that's what's going to take. Because Bev she's reading from a piece of paper. And so when they would have had this piece of paper back there to see, like, and if there would have ever been a question, like, wait a second, that letter doesn't seem right. That letter seems like we haven't come to any type of conclusions and we have no verdicts on anything. And that's not the case. So, that's that's what's going to have to come out. And people need to say that, we did those things. He told us that nowhere did it say that all of the people had to know what he was writing, the letters. He just was doing the communicating. We had no idea what he was writing. That's what's going to take. And if that comes out, then I think that something can be done, because then it's a different approach on how you would be able to, it's called, in order to show that there would be influences. And that would be grounds that the courts, as well as the lawyers, could talk to these jurors and ask them for them to talk about this. And it's going to come down to that there was outside influences, or AKA the foreperson completely wrote things that just, led the courts to believe that we were at an impasse on all of this, and we weren't. That's what's going to take. And it's going to take calling out the foreperson. If that's the truth, don't go lying. You know what I mean? Don't go, just tell the truth in there. And when you tell the truth about what went on in there, in terms of that, I mean, but sitting here to say that Bev, as far as the jury instructions, she says it clear as day. Write me and ask me if you have a question. And so if I have a question, okay, here, fine. You may not have the question, but I want the foreperson, since you're the only person I can communicate with, write my question, which is, we have come to a unanimous decision on some of these counts. Do you want us to fill out our slips for that? And then we're going to keep, deliberating on these other counts. But how would you like us to do that? Because based on the instructions, it said that until we had a unanimous decision on a verdict, which we do on count 1 and 3, and we do on part 2 here, count 2, but we're still working on the lessers. But we were 100% allowed to tell her when we've reached a unanimous decision on counts. And so, and if somebody in that courtroom or in that deliberating room would have said, if you would have seen it differently than me, then I'm going to write it like that. A couple of the jurors see it like this, and a couple of the jurors see it like that. So we have a question on, if we've come to a unanimous decision on certain counts, should we be disclosing that to the courts? Not necessarily what if it's not guilty or guilty, but us writing that we're at an impasse is not true, because we're not at an impasse in some of these charges. So why aren't you writing that? And if anybody is reading that and it says ask questions, ask questions, ask questions, then why wouldn't you do that? I understand that the courts couldn't accept it if it didn't come from them. My point is that if I'm telling the foreperson to write it and they do not write the note and send it in, okay, then that's an influence. You have to look at case law, and you have to look at the laws as to how, if you want Karen Reed's count 1 and count 3 to go away, you have to do it based off of like precedent, based off of laws that would allow it. And it's going to be not because, oh, hey, we're coming forward because, hey, just so you know, like, we totally were unanimous on this and this. You have to make it about, we're not talking about your guys' this deliberating process or anything that like that. We're talking about, why didn't you guys fill out your slips as you were going? And why was there no slip being, okay, hey, impasse written there, not guilty, impasse, turn it in. Who decided that they would write these ridiculous letters, notes that aren't questions? They're statements, and they're so worded and using language from past court cases. No gifted memberships right now. Don't want a troll getting it. Again, welcome to the transparency. But there you have it. You guys can go back and see what you think. But I will continue this to talk about what then happened. Then you want to talk about the jury slips being confusing. That's a whole nother thing in itself. But the instructions, guys, the instructions that she just went through and that she read verbatim, the things that bother me is that she only passed out 3 or 4 copies. So then we know for a fact that not everybody went into that room and had a copy to be reading to themselves. But what they would have had is, when you're talking about things and saying something, oh no, I know that I heard her say that. Let me see this. Let me go find what I'm trying to say so that I can prove to you what I'm saying and that it holds merit. No, that's not true. Dre Latina, I just played it. That's 100% not true. 100% false. Bev told the jury not to return a verdict unless all decisions were completed on the slips. Not true. When did she say that? It has not happened at this point. So that just didn't happen. I played it the whole thing up until this point, which is...
You were going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final...
With the verdict. Like, each count has its own verdict. Okay. That's the truth. So listen to that again. Because if we're going to judge, then we have to make sure that we know what Bev said. But guys, at the end of the day, you ask questions. You taught that in first grade.
You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate.
Right here, listen.
At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You were going to notice shortly...
Before such time that you reached a unanimous verdict on, because there's different verdicts on each count. And if you didn't think that that's what it meant, then you ask that question. But there is no way in hell that it makes sense that you allow somebody to write a letter that says that you are at an impasse when you are not on everything. And then somebody would have to come forward and say that we as a jury wholly thought that all of it was all or nothing. Either we decided every count or we're at an impasse. They're going to have to come forward with that. And it's not going to be through, confidential informants. No, get your ass up off your couch and march your ass down there and do the right thing. Okay.
That the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain.
You guys, the defense and the Commonwealth helped write these jury instructions. You guys understand that, right? She says it earlier. I'm not going to go back for people that just are getting it now. You're going to have to just rewind it. She says exactly. I think she breaks it down. But at the end of the day, you have questions. She simply says, "Hey, write me if there's questions, and I will then present the questions to the lawyers, and then I'll be getting back to you." Okay. And all that I would be focused on is that on that fourth time when that happens, that is not the way that she did it. She did not get the question, read it then to both sides without the jury present like she did on every previous one. I'd be focusing on that. And then, in fact, then she called them in. So everything that she done the last time, that's what you want to focus on, that it wasn't like the other times. But those letters screwed Karen Reed. Why were you writing letters to the court versus you're only supposed to write them if you have a question? Those were statements.
And that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to seek counsel before we reduce your number.
Right there were verdicts. See how she just used the plural there? So that's another thing that I would argue. But these defense attorneys are going to have to break this all down and show that she should have been saying the word verdicts versus verdict, because listen to what she says right here.
Notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court.
Where the foreperson will deliver the verdicts to the court. That's the first time that she uses the word verdict in plural. Okay? So if there's any issues here, I think that the only thing that I've had a problem with this from jump is that the word verdict was being used versus verdicts. Okay. That's come out on my channel from jump. Said it the other day. And in fact, when the jurors wrote the first letter, they used the word verdict.
I'm going to seek counsel before we reduce your number to 12.
So right there, if you ask yourself this, if you would have been one of those people in the room and you were like, wait a second, hold on, look at this right here. Why are we writing anything? It says that you're going to read off the verdicts. So you're going to read off the verdicts. So we have a not guilty here. We have a not guilty here. We have not guilty on count 2, then we go to the lessers and we're hung. Okay. So again, why was the foreperson after a long weekend, or just I can say it's a long weekend because it was a long week leading up to that weekend, the foreperson's letter on Friday did not match in verbiage of what happened then on Monday, the language that was used in those letters, and it was using vocabulary words that were from literally precedented court cases. Huge problem with that language. And versus your job was to do what? Here's our verdict slip, and these are our verdicts. So count 1, not guilty, unanimous, sign and date that. Count 2, not guilty, but then the lessers is hung. Then you go to count 3, not guilty. And then you turn it in, right? Then what would happen is, like always happens, is that the judge looks at that and she would then say, okay, wait, all right, so you guys are hung on this. And that's where it would be like, put the ball in her court, make her say, oh, wait, no, this isn't how this works. You have to have, all of them would have to be, have to have a verdict. But that's how you would do it. I would say, no, we're not telling her anything. We're filling out this juror slip like we're supposed to do it. We have come to a conclusion on this. Put not guilty on number 1. Right? We all not guilties? Okay, put down not guilty. All right. Then we go to count 2. We say unanimously, we don't believe count 2, she's guilty. So we're going not guilty, but then we get to the lessers and we are hung. So write those down, hung. Then go to count 3. What are we? Unanimously. Now turn that into the courts. Do not say shit. And then they will then tell us, hey, that's not how this works. And you need to then unanimously have everything, or otherwise it's a hung jury. But why are we writing some bullshit? Okay. Because if you go with the instructions, fill out your slip and then let them say, okay, wait, hold on. Let me get this straight. You have a verdict here, but this is where you're hung. And it's like, to be honest with you, they didn't listen to the instructions and they didn't read the instructions. Because if you would have and you were confused, then you would have had questions about that process. And I'm sorry, it's not, you can't go blaming Bev for everything. You can't go blaming the Commonwealth for everything. I think that they are completely off the fucking rocker. I don't think they should have ever fucking came to court, trial, whatever. I think Karen Reed is not guilty across the board. But here, I'm sorry, the jurors are going to have to speak up and say that there was influences in that deliberating room that told us we were wrong and no, and we had no idea that he was writing these letters and this is what they said. It's, you have to listen to that part too. You guys, again, I have a problem with the word verdict being used instead of verdicts. There should have been multiple, the word verdicts should have been on there, plural. Okay. Because you're coming to a verdict on different counts, right? But she does say verdicts, and then your foreman's going to read your verdicts. So it's just, I agree, Frank, 100%. That's what common sense would tell you. We have a form in front of us, guys. And like I said, as we're going by it, hey, what day and timestamp do we come to that we've decided that first degree or second degree is off the table? So I'm writing not guilty on mine, because remember, we still have to have all of our own slips. There's not just one slip. Everybody has their own slip. So here's mine, and I'm writing not guilty. We decided this at timestamp this, and I'm initialing it. Then we decided, obviously, count 3 kind of goes with that. So we came to the conclusion that we all said not guilty to count 3 because it has everything to do with knowing. So not guilty, my initials and timestamp. And everybody should have their slips, okay? And everybody should have their slips, and their slips are in front of them. And then now here we are debating count 2. So collectively, I'm going to gather all of our slips. Here's all of our slips. And then here's the actual foreman tallied up slip. Okay. And with all of our slips behind it, here's the top one on top, and there you go. And if you're looking at the slip and you're like, okay, count 2, wait, this doesn't look the same as these other ones, then you would have what you have and what you would call is a question. We are confused about count 2 and the way that this is all laid out. And you guys, you have to ask yourselves a question, okay? And it's people do this all the time when you're putting together furniture and you don't read the instructions. There was only 3 or 4 sets of instructions, and I personally believe that not a single one of them read those instructions. They may have glanced at certain things when you want to talk about the counts and talk about the elements of each crime, that you have to meet each element and things like that to do your deliberating. But absolutely, I don't believe that anybody read those. There was only 3 or 4 copies, and if they truly had questions, they were talked out of asking those questions to the court, and it's going to take people coming forward and saying that, and that would be called extenuating circumstances with influences, which is basically jury tampering, okay? And if you can start getting on that path, if these jurors believe that this was jury tampering, then that is how Karen Reed can have counts 1 and 3 dropped, but not off of this bullshit where intermediaries are talking and confidential informants are talking. No. This is going to be people that are coming forward that are straight up saying, hey, I am not going to tell you how we did anything in there, how we deliberate or anything like that. What I'm going to tell you here is that we had questions and that foreman refused to write our questions and send them in. And had he done that, we would have had our answers and our verdict slips would have been filled out, but he refused to send those in because he was saying, no, trust me, I've done this before because I have a cop, whatever it may be. But it is going to come out, and it has to, otherwise everything's on the table for round 2 because it doesn't hold it. You're going to have to say stuff like that. And if you don't, then I'm telling you, as it should be, Karen Reed's going to be facing these charges again. But I personally believe that Karen Reed facing these charges round 2, this is coming back in an hour. Because you just broke it down an hour ago. I have no idea what the hell these jurors were doing in that room when you're going through the elements of this. And it was that bad. It's bad. It's bad. And maybe these people don't realize, maybe it's going to take them. They should listen to those jurors' instructions again and play it and think to themselves, wait a second. I straight up asked that. I said, wait, why aren't we turning this in? Wait, what's going on? And I was influenced with wrong material. And then people were backing that wrong material saying, oh yeah, it's right here. It's read like this. It's read like this. But those letters written to the courts are so problematic. That foreman writing those letters, it honestly looks like he did what he did on purpose. Those letters had language in there that was from precedented case law, and then it was precedented case law that Lally cited in his motion, or not his motion, but his reply. I mean, it's sick. A foreman is the one person who could have spoken up. He didn't. He didn't for a reason. He knew exactly what he was going to happen, as did Bev. She knew it was all too swift. Yes, but guess what? That can all be corrected now, and it has to be corrected in the manner of that. Wait a second. We were under the impression that letters got sent and questions got sent. You know, I'm like, think about that. Or we wanted stuff to get sent and they didn't get sent. Or, but it's, if you read what it says about influences, if you can start talking about these influences, that's how this could change. And it's going to take jurors saying that it's basically jury tampering. So she talks to them at sidebar. All right, sidebar over there with Bev. I sent you in there, but it looks like free Karen Reed. That's gonna wrap it up here, though. How many of you guys lasted doing your sips? I'm sure Sherry D was loving it. Again, this channel is 100% pro free Karen Reed, like you wouldn't believe. But you guys, this was not. I can't. I'm not. I will never be bought and paid. You have to call a spade a spade. That's how you keep your cred where you need it to be. But this, I'm sorry, I cannot put this on Bev. I believe that she read from the piece of paper. If you can prove that the piece of paper, that she varied off of the piece of paper, but the piece of paper that had all the jury instructions were given to them. And this one is totally on the jurors. I'm sorry. And the jurors can make it right. If it in truth should be right, you know, some of these people are going to have to hold accountability and say, oh my God, I did not read those jury instructions, you know, looking at those jury instructions, like why didn't we, like, why aren't we filling out our jury slips as we're going? And it just bothers me when you want to hear people say things like, you know, the defense attorney saying in an affidavit, like, these people just don't feel like it's right. Like something isn't right. Something isn't right. And it's like, then you should have had those feelings in the jury deliberating room when you're like, something isn't right that we're writing a letter like that. That we're going and telling we're supposed to just ask her questions. We're not supposed to send her fucking love letters like legal S, you know? Don't even get me started, man. I'll go off, and I don't want to go off. And it's sad because this across the board. I mean, second graders, third graders could tell you that Karen Reed's not guilty based on simply that the Commonwealth didn't prove their case on any of the counts, right? And you know why I think second and third graders could prove that is because it's like a story. It's like a story. A second or third grader could be told a story. And if it doesn't make sense to them, that's how you would ask a second or third grader. Did that story make sense to you? If it made sense to you, put a check mark. If it didn't make sense to you, put an X. And I think that those second and third graders would be putting X's. And that would signify that you didn't prove your point. You didn't prove your case because these kids can't even follow along. You don't give a jury, you don't tell them your verdict. The jury cannot give the court a jury note telling its verdict. That's not what you do. You give them a note, aka screw even the word of a note. You give them the jury slip with it just simply filled out. Not guilty is not guilty. Guilty is guilty. And if it's a hung jury, say, we can't come to a decision on this. We're hung. We're hung. Decision, hung. That's your slip. You turn it in. And then you put the ball in their court to say something about that, to say, wait a second, no. But they wouldn't have said anything like they wouldn't have said, wait a second, no. Okay. They would have said, okay, well, here, go back and start deliberating again, because that's what case precedent would tell you. And guess what? If they started deliberating again, case precedent would tell you that if you still can't come to a unanimous decision on those things that you had, you still have to write your slip in and put it back down again. Not guilty, not guilty, not guilty, hung, and turn it back in just like that, signifying that you're still hung on those counts. Because let's say that after you are told to go back into the deliberating room and you don't turn something in like that, then guess what? It's considered a mistrial across the board and all the freaking charges are still there. That's what case law says. And that's what Lally is citing in his reply. It's truly unfortunate. It's truly unfortunate because those jurors said that that they were ready to get the case, that they were all paying attention, and then you don't pay attention to the last most important hour when it's specifically this person, the judge, is talking to you, and then it's okay, like, hey, I'll then read it, or you failed Karen Reed. Okay, that's the facts. That jury as a whole failed Karen Reed. I'm not sure if they can make it right, but period. Sorry. It's just fact. But I'll be on later. Run it back. Let me know what you think in the comment section. And they should feel this shouldn't feel right to them. Okay, but take accountability. And we're not gonna, and us as watchers of this aren't gonna just go pointing the finger at Bev. And if you do without truly going back and analyzing it all, then I'm just sorry, but you're a follower. But for this, I think that people need to take accountability. And it should teach us all that no question is a stupid question. Ask questions. But the jury wasn't asking questions. That foreman was writing statements, and that's not what's supposed to happen. And Bev called it out. I've never seen a jury note like this in my life. Yep, because it was wild.